that an issue for a later day when both parties have had a chance to go through the 526 issues?
Well, the question is if that money goes forward and it's already been wasted, there's no way to get it back.
And I understand that, but what you're in effect asking is that the court preclude the state from utilizing the monies that are being provided by the federal government because of the anticipation that you may be successful on the 526 action.
I would say that basically that the part that we're concerned about in terms of the use of federal money, and we're not talking a long time period. We're talking that we'll discuss in the case management conference. We're talking about until we can get that case to trial, those costs of action to trial, which I would think is a matter of a few months. And what we're basically just saying is you should issue a TRO against spending any federal money towards construction, because the other money arguably is not wasted. If you're doing planning, arguably you could plan something and maybe figure we'll find another way to finance it later. But until you actually start building the actual construction, you aren't building something that is kind of, well, now we built it and it doesn't have any use and it's going to, basically go to waste.
Ms. Zinon, do you want to say anything?
Yes. First of all, the 526A claims are based on the same legal claims as the RIT claims. And if the RIT claims are denied for lack of a remedy, then the waste claims aren't necessarily decided. Furthermore, there would be no grounds for issuance of a temporary restraining order on use of the federal grant. The use of federal funds is not even a claim in the Second Amendment complaint. Therefore, restricting the state's use of that under this complaint would be highly improper. In addition, there's case law that indicates that temporary restraining orders or any kind of preliminary restraining orders are inappropriate in waste cases. This is because taxpayer allegations of waste just aren't irreparable injury, at least that's been defined by the court. The relevant case is White v. Davis, and I think we cited it in our papers. There's just absolutely no reason, both legally and procedurally, to enjoin the use of federal funds while this case continues.
Thank you. Mr. Glassman?
Your Honor, first off, I have to again disagree on whether the 526A actions are essentially rendered empty by the.
Let me interrupt you, though.
Sure.
I think we have migrated. One of the difficulties at this point in time is that the court requested a hearing today to talk about particular remedies for its findings previously. The 526 action is a part of this case, but we've now migrated into, in effect, a sensible request for a TRO on federal monies. Neither party has actually provided any true briefing for a TRO on that issue. The state would be at a disadvantage on that.
Leave that for another day?
Well, I think it's premature at this point in time. We're going to have a case management conference after this particular hearing to talk about the 526A action and how we were going to proceed on it. It just seems like we've jumped the schedule. Counsel, want to point something out to me that I might be missing?
I just want to add one more thing on this is on the actual remedies we're talking about here, and that is the nature of the injunction that we're asking for in terms of the expenditure of bond funds on the construction contracts. And essentially, it may be that the authority is arguing we're not going to use any bond funds, we're not committing any bond funds. Then essentially, what's the problem with issuing that injunction? Why are they so strongly opposed to having that injunction issued if it isn't going to interfere with what they're actually planning to do?
Ms. Zinon, do you want to respond?
Well, they haven't proven that the authority has entered into any commitments that violate the requirements of subdivision D. Therefore, there'd be no reason to issue an injunction. The authority has every intention of producing a subdivision D funding plan when it needs to use bond funds to construct.
All right.
Well, Your Honor, I think there's a difference between when you're planning to use bond funds and when you're planning to commit bond funds. And I think the idea of the injunction was to prohibit the authority from using or committing bond funds towards construction, which is basically saying you are limited in terms of what you can use and in terms of what you can commit bond funds to the amount of the subsection G and H. And if you're going beyond the subsection G and H, you are necessarily committing bond funds to construction or to the subsection D activities. And that's the reason is basically to say you need to be aware that you're not just free as long as you don't actually start using the funds towards construction. You're not free to just go ahead and commit them in a way that will eventually result in their use.
Any final words you'd like to add, Mrs. Eichner?
I misspoke when I spoke last. A subdivision D funding plan will be approved and submitted to the appropriate people when the authority needs to commit bond funds for expenditure. I have one last preliminary matter, and that concerns the other writ claims that were pled in the Second Amendment complaint that weren't discussed in the court's ruling. The defendants would ask that all the pled writ claims be dismissed since we had a trial on the merits of those claims. That all of the remaining claims were unaddressed by petitioners in their papers on the merits and should be considered abandoned. And at the hearing on the merits in May, the petitioner's counsel indicated that all those claims were not right anyway. Therefore, we'd ask in a final ruling of the court that the court dismiss all writ claims that are pled in the Second Amendment complaint. In addition, in the state's opposition on the merits, it asked for dismissal of all individual defendants as well and provided briefing on that, and we would appreciate it if those defendants could also be dismissed from all the writ claims.
Mr. Fleischman?
Your Honor, in terms of the writ claims that were not followed through on, I think it would be, because we agree that some of those claims are not right and they could be dismissed as not right. In terms of individual defendants, I don't think we do agree, because there is still the potential of having to enjoin actions by individual defendants. And if that's the case, they need to stay in the case.
All right. Submit it.
May I respond to that just briefly?
Briefly.
The only authority that is authorized to commit or spend bond funds is the authority, and that authority would remain as the defendant in the action. I'm asking for dismissal of the individual defendants, including the governor, the controller, the treasurer. Those people would not be involved in any injunction that could be issued by the court.
And she seems to be correct, Mr. Fleischman. Why would they be?
Well, to the extent that the controller, for example, is responsible for dispersing funds, then if there's a violation of subsection D, we ought to be able to tell the controller you can't disperse those funds because it's improper.
But don't you accomplish the same objective if, in fact, the authority is enjoined from any expenditures?
If I think the answer is if the authority gets the funds, they shouldn't be getting the funds. It's not, in other words, maybe the end result may be similar, but the funds really shouldn't even be going to the authority if they were improperly, if the requirements for the controller to release those funds have not been satisfied.
It isn't a fundamental claim against the authority, and to the extent that the authority is subject to any injunction that may be issued, the other parties are almost irrelevant. And we're anticipating what may or may not happen. The real focus is still on the authority.
Again, I have to think about that.
All right, I'll leave it there. Any other comments you'd like to make, Mr. Fleischman?
And that they can just roll on forward to the subsection D plan and ignore the fact that they didn't prepare a proper subsection C plan. I think, again, we've talked about the fact that the subsection C plan is the only funding plan that addresses environmental clearances. And as we pointed out in our briefing, the reason for not addressing the environmental clearances in subsection D is because the assumption is that they were properly addressed in subsection C, and what more is there to add? But if they were not properly addressed in subsection C, you really shouldn't be able to go on to subsection D until you have addressed them.
All right, thank you.
Yeah, I do have, excuse me, Your Honor, I do have one point to make. Way back in March, when the first round of briefing was filed, our opening brief cited extensively a case called Van Etta, a Supreme Court case, and that deals with the exposure of the individual defendants here. The Supreme Court said those who authorize or participate in any manner in the disbursement of the funds and so forth are properly in the action under declaratory relief under 526A, injunction, and so forth. I just remind the court that was presented several months ago.
Your Honor, and actually, in terms of the dismissing the defendants, even if you would dismiss them in the writ action, they really need to be included in the 526A action, because in the 526A action, we're potentially looking at invalidating the appropriation, because that's where the 526A action may well be headed. And if that's the case, then, for example, the controller absolutely needs to be included in the case.
All right. All right, submitted.
Yes, Your Honor.
Submitted.
Thank you all. All right, if I could see